Oh, for the prosecution. Somebody else. Communication goes. Yeah. Yeah, they got big trees. It's just a matter of time. We're good. Now, that's just what company calls. No PCCs today. How about
That's it.
that?
That's an afternoon doctor.
Right? Good, man.
I'm good. How are you?
Have a good weekend. Here. Oh, wow.
It wasn't bad.
Just trying to- oh,
I'm just trying to learn.
yes.
How was your?
You bet.
You know, private students?
Absolutely. I think that's supposed to be done today.
According to Joyce said I might be in for a week, but I don't know, for sure.
Good morning, Mr. Jersey.
Good morning, Your Honor.
How are you today?
Fine, thank you.
Good. So we're just waiting on the APAs to get here.
Okay.
you know who the APA is? Good morning, Wayne County. You're on mute, sir.
Morning, Judge. How are you?
Doing good. How about yourself?
All right. We only have Mr. Frederick Barnett for you today.
Okay, we're just waiting on the APA to get here. His attorney is here already.
Video carrier.
Okay, I'll get him there.
Yeah.
Here's Ms. Moore. Perfect time. Good morning, Ms. Moore.
Good morning, Your Honor.
If you guys can give me just a moment, my clerk stepped away.
Thank you.
Did you guys have a competency report?
Your Honor, for some reason, I have not received this competency report yet either. I have called and emailed and still have not received it. Did the court receive a copy?
I don't know yet. I gotta wait till my clerk gets back. Mr. Jersey, have you received a copy of the competency report?
I did receive the competency report last December. He was found incompetent to stand trial, and you ordered him to undergo treatment to render him competent to stand trial, but I don't believe that treatment has begun. They sent me a letter back about a month ago, May 16th. I think it's a copy of a letter that was sent to Your Honor, and it states that Michigan Department of Health and Human Services is appointed as a medical supervisor, and it's in the center's placement recommendation that the defendant's competency restoration treatment be provided in the inpatient hospital setting. But it states also that the treatment, as Michigan hospitals are experiencing a high volume of inpatient service demands, and as such, there will be a delay in the provision of this treatment, and that's the last information that I got.
Let's call. Barnett. See. Hmm.
May 16th? Calling case 220-600-9701, the people of the state of Michigan versus Frederick Barnett. The defendant is charged with count 1, criminal sexual conduct, 4th degree. The defendant has a habitual offender 4th offense notice. Today is the date and time set for a competency hearing. Appearances, please.
Good morning, Your Honor. Elizabeth Moore on behalf of the people, P84724.
And Robert Jerzyk, P33195, on behalf of Mr. Barnett, Frederick Barnett.
And jail is supposed to be putting on Mr. Barnett. I think they want to go get him. So it appears as though I have the same letter that Mr. Jersey has dated May 16, 2023, indicating that due to the high volume of inpatient service demands, there's going to be a delay in his treatment. So I take that to mean that he has not been treated yet, and so his condition has not changed either. So that being the case, the court has no other choice but to adjourn the competency hearing. Let's put it out another 90 days. To September September 12th at 8:30.
September 12th at 8:30.
Yes, sir.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Have a good day, guys.
Thank you.
Thank you.
Good morning, Mr. Barnett. Unmute yourself, sir. I know who you are. Can you unmute yourself and tell the deputy to unmute you? I can't hear what you're saying. Yes, sir. I can read your lips. I know you're Frederick Barnett. I need you to unmute yourself. You're on mute. Can you get the deputy for me? Get the deputy. Yes. Hi, deputy. Mr. Barnett is all set. His next court date is going to be September 12th at 8:30. He's going to be referred for treatment.
Okay,
All right, thank you.
okay, Mr. Barnett.
You're all set, Mr. Barnett. Thank you.
We'll take Mr. Barnett back. Let me get his card. Hold on.
Say we just had one example. I think so. You've been on the road lately, Michelle.
Pardon?
You've been on the road lately.
Oh.
People showing up.
Oh, I know. I know. No, we'll have some today, so we'll see. Fingers crossed.
Ms. Segura,
Yes, Your Honor.
why are you on Zoom as opposed to being here in court?
Because I had filed a motion, to, withdraw from the case. And I had spoken with you about it, I believe, Wednesday of last week, and you told me to come on Zoom. And so I have told,
Yeah, you're correct. Okay.
okay, I'm about to call Miss Langford, and see if she can Zoom in now.
Okay.
You were aware of that, right, Ms. Segura?
Miss Langford is signing on now, Your Honor.
Okay. Do all your clients wear rags on their heads, Ms. Segura?
Seems that way, Your Honor. Miss Langford, if you could please remove the cap on your head.
Okay, here we go.
Take the scarf off, ma'am,
Oh, shit.
and watch your language.
Okay, I'm sorry. I'm ready.
All right, okay. Calling case 2357105, people of the state of Michigan versus Donetta Lee Langford. Defendant is charged in count 1 assault with a dangerous weapon, count 2 aggravated domestic violence. Appearances for the record.
Good morning, Your Honor. Shelley Drain for the people, key number 60249.
And good morning, Your Honor. Alyssa Segura with the Neighborhood Defender Service on behalf of Miss Langford, P86432.
Tell me your name, Ms. Langford.
Donetta Lee Langford.
So the day is the date and time set for preliminary examination. Mr. Segura contacted the court last week indicating that there is a conflict of interest as it relates to her representation of Ms. Langford. I indicated for her to sign on today via Zoom, and we will assign Ms. Langford new counsel, and to also contact prosecutors, let the prosecutor know not to have witnesses come down unnecessarily. All right, everybody has upheld their part of the bargain. So we're gonna contact the assignment clerk now and get Ms. Langford new counsel and pick a new exam date.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.
Just hang on tight, Ms. Langford.
Okay,
Sign on so they can talk to you.
okay.
Am I all set, Your Honor?
Yes, you're all set.
Thank you, everyone. Have a good day.
I'm gonna put you on mute real quick, okay, Ms. Langford? You got a lot of noise.
They're gonna have someone zoom in, so
Yeah.
they're gonna have someone zoom in. Rock is walking across the street since we had 8:50. Walking across the street.
Mr. Mercier is seated. Good morning, Mr. Mercier.
And good morning. I received a phone call from Assigned Counsel Services that you need a attorney today.
Yes, for Donetta Langford. This is her on Zoom. Would you like to go in a breakout room with her?
Yes, I would, Your Honor.
Okay, 1 second. Go ahead and join the breakout room, Ms. Langford, Mr. Mercier. Join the breakout room, ma'am. Unmute yourself. I can't understand what you're saying.
It's not popping up on my screen for me to join it.
Give me a second. I'm gonna have to bring him out and put you back.
Look, I'm back.
Okay,
Hold on a second.
okay.
Did you see anything like that in person?
Well,
I did.
I did, but that was in 70.
This would have been 64.
Hey, come on. You're on George? Yep. Calling case 2357084. With State of Michigan versus Brian Keith Jordan. Defendant is charged with count 1 assault with intention to great bodily harm, less than murder or by strangulation. Count 2 domestic violence, third offense. Appearances for the record, please.
Good morning, Your Honor. 0249.
And good morning, Your Honor. Good morning to your staff, Neighborhood Admin Services. Ken Riggin, the 82125. On behalf of Mr. Brian Jordan, state your name for the record.
Brian Keith Jordan.
Date and time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is Ms. Sherry Clark. She was notified of today's date and time for the exam. She is not present. I cannot speak without her today.
Your Honor, and the prosecution's statement, I will get dismissed without prejudice.
Well, we'll dismiss this matter without prejudice. I'm related to a Sherry Clark. Is Sherry Clark African American? Okay, good. All right.
You almost say.
Okay, Mr. Mercier, you ready on Langford?
Yes, I am, Your Honor.
Okay, you can call Langford. Or recall Langford. I'll do it direct. Recalling 230571050 people versus Donetta Lee Langford. Appearances for the record, please.
Good morning, Your Honor. Shelley Drake for the people. Key number 60249.
Good morning, Your Honor. Attorney Daniel Mercier, P 72620, representing defendant.
And Ms. Langford, tell us your name for the record. Have to unmute yourself, man.
Oh, it's muted. Donetta Lee Langford.
All right, so Mr. Mercier has just been appointed to this case. Are you demanding an exam, sir?
Yes, I am, Your Honor.
Okay, the court will continue the plea of not guilty and set this matter for preliminary examination. We'll set it for it's June
What date was it,
26th.
Your Honor?
June 26th at 9 o'clock.
I can do that, Your Honor. $626.
Will be in person, Ms. Langford, on June 26th at 9 o'clock. Trial will be continued.
Okay.
Thank you, Your Honor.
Mike, you ready on Lewis?
Yes, Your Honor.
Calling case 2357107, people of the state of Michigan versus Adriana Lewis. Defendant is charged with count 1, assault with intention to do great bodily harm, less than murder by strangulation. Count 2, felony firearm. Count 3, assault with a dangerous weapon. Count 4, felony firearm. Count 5, aggravated domestic violence. Appearances for the record.
Good morning, Your Honor. Shelley Drake for the people. Key number 60249.
And good morning, Your Honor. Oral Water, hearing on behalf of Mr. Lewis, 4153.
Ms. Lewis, tell us your name for the record.
Adriana Lewis.
Date and time set for preliminary examination. Are we ready to proceed?
Your Honor, I am not able to proceed at this time. The complaining witness is a named Gerald Shirley. He was notified of today's time. He is not present. I cannot proceed without his testimony.
Your Honor, I would move for dismissal.
So order, the court will dismiss this matter without prejudice.
Thank you, Your Honor. Thank you.
Yeah. Anybody here on Jackson? Yes, yes, sir. It's just no consistency. What did you say about it? Civilian, it is a okay. Yes, Ms. Jefferson? Did you get my text?
No, I,
Yeah, why do you treat me so bad?
oh, I see, I did, that's why I didn't get you. No, I did. Okay, you tried to get here. You got paid. I always know why you go there.
I don't know why you go there. You always treat me like this.
Oh, I was running, you know I'll be on Zoom before I get here.
All right, calling case 2357101, Sequel State of Michigan versus Antonio Jackson. Defendant is charged with count 1, home invasion, first degree, count 2, felony firearm, count 3, domestic violence. Cases for the witness.
Good morning, Your Honor. Shelley Green for the people, P number 60249.
Good morning, Your Honor. Thomas A. Jefferson, on behalf of Antonio Jackson, 4287, Mr. Jackson stands to my down.
Antonio Jackson, sir.
Today's the date, time set for preliminary examination. Are we ready to proceed?
Yes, Judge.
How many witnesses will be?
Just one.
Call your witness.
At this time, the people will call Ms. Latanya Waters.
Good morning, ma'am. Please step forward. Give your name and spelling of your name to the young lady waving at you over there. Please raise your right hand. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please have a seat in the witness box right next to me. Voice that nice and loud, speaking to that microphone is to you. Thank you. You can pick that up and place it in your lap and speaking to the force, okay? You can pick the whole thing up and put it in the lap. Okay. You may begin when you're ready.
Thank you. Good morning. Please state your name one more time for the record.
Good morning, Latoya Waters.
All right, Ms. Waters, I'm going to be asking you some questions today. If you don't understand something or if you want me to repeat it, please let me know, all right?
Okay.
Okay, thank you. Ms. Waters, I want to bring your attention back to the date of May 27th of this year, 2023. Do you remember that date?
I do.
Okay, and where were you on that date?
At home.
Okay, and where's your home located?
926 Alger, Detroit, Michigan, 48211.
All right.
Alger, ALGER.
All right, and you said that's the city of Detroit, county of Wayne?
Yes, ma'am.
All right, thank you. And so on that date, were you, first of all, is that your house?
Yeah.
Okay, and on that date, were you home alone or was there anyone else with you on that? There at your house that day?
My family was there.
Could you indicate what members of your family were
My
there?
mom, my sister, my nieces and nephews, and my 8-year-old daughter.
Okay, and what's your 8-year-old daughter's name?
Margaret.
Margaret? Okay. Okay, and did anything unusual happen on that day at that?
It was a long day, specifically in the evening, around almost 12:30.
So this is like 12:30 a.m.?
Yeah, and
Okay.
well, you want me to do one for my name for now?
No, that's okay.
Okay, so, yeah, I was at home my bed around 12, after 12 a.m.
Were you asleep or?
I was asleep.
Okay,
And,
and let me just stop again. So you're in your room?
yeah,
Was anyone else in your room at that time?
no,
Okay, so you're home in your room asleep. What happens next?
Antonio Jackson, called my room.
Okay, let me stop right there. You said Antonio Jackson?
Mhm.
How do you know Antonio Jackson?
We share kids,
Okay, and is that your daughter, Aubrey?
yes,
Okay. Now, does Antonio Jackson, does he live at your home with you?
no,
Has he ever lived at your home?
he hasn't lived with me for years,
For years.
for years.
And so your daughter is 8. How long have you known Mr. Jackson for?
Probably 10 years.
Okay. All right, so you indicated you received a phone call around that time from Mr. Jackson?
Yeah, so he called me and I answered the phone and I said hello. He said, I'm coming to get my stuff. And I was like, it's the middle of the night. You know, everybody's sleeping, come back in the morning. And, you know, it was like very casual. I looked at the phone.
Okay, let me just stop you right there. So he called you and said he wanted to pick up his stuff, is that what you said?
Yeah, I mean, he cursed probably.
Okay.
Okay.
So did you know what he was talking about?
Yeah, he had a few bags in my house of things from like a month ago, a month before he had got into an altercation with someone. He asked me to store a few things at my house.
Oh, okay, so these were just things that he had stored at your house?
Yeah.
Okay, so it wasn't daily
No,
thing.
he didn't come and get stuff out of them daily. You know, it wasn't like an everyday thing. It was there for, I had talked to him for maybe 3 weeks before he called me this day.
Okay.
So it was random for him to call me in the middle of the night and say, hey, come and get my crap. You know what I mean?
Okay. Okay, so you told him to come in the morning?
So I said, you know, it's the middle of the night, everyone's asleep. Can you come pick your things up in the morning? And, you know, he became irate, but then I hung up the phone because I was in the middle of my sleep.
Okay.
And so maybe like an hour later, he called me to say, I'm outside, I'm coming to get my stuff right now. Like, and I'm like, I told you it's the middle of the night. Just come get your things in the morning. Everybody's asleep. You know, that's what I kept reiterating. Specifically my mom.
Why specifically? You mean your mom was asleep or your mom was there at the house?
She was asleep and there at the house.
Okay, why did you not want him to come there if your mom was there?
Because he and her had like a previous like altercation. And so he, you know, it's really not allowed over my house.
Okay. And you told him before he wasn't allowed at your house?
He knows this, he doesn't even, that's why he doesn't come to my house.
Okay, so he calls you and says he's there to pick up your this up.
Mm-hmm.
What happens next?
So, he got banging on my window, banging on the door.
Okay.
He kept calling my phone.
He kept calling your phone?
I answered, I said, hey, I told you, come back in the morning, like, it's the middle of the night. And you just like, forget what I'm saying. And he's like, I'm here, open up the door right now. He got to banging harder and banging on the window. Saying, I don't care if I break it. So next thing I know, he's coming through my window.
He's coming through your window?
My bedroom window. I'm still in my bed at the time, talking to him on the phone.
Okay, let me stop me there for a second. You said he was banging on the door, so you're saying your home door, like your exterior door for the home?
Yeah, so like the way my townhouse is, I have a front door and a back door. The back door is really close to my bed.
Okay.
So maybe, just give an example, maybe where this side of here is, and where they get away from the big kids.
So the side of the mirror would be what? The wall would be what? The door or the window?
The door and then the window. They're very close.
Okay, so just a matter of feet?
Yeah, a matter of feet.
Okay, all right. So was it the front door or the back door?
It's the back door.
Okay, so he's knocking on the back door and on your bedroom window, which was very close.
Very close. Very close.
Okay. So you said did you say he opened the window?
Yeah, my window doesn't lock anymore.
Why doesn't your window lock anymore?
because of the altercation that he and I had previously, like, before, like a year or so before. But, anyway, he opened my window and he climbed right in my window, and I'm like, I sat up on the edge of my bed, and I'm like, what are you doing? I'm on my knees. And he pushed me off my bed, and I fell onto the floor. Literally, like, my bed is kind of high. It's about, I have to use a special thing to get in it. Anybody will do now. But I fell, and I fell on my arm and broke my leg.
Okay, so he pushed you
Yeah,
and you fell off the bed.
when I fell, that's when my sister and my mom came, and they were trying to stop him, from tearing up my room. And they were asking him like to just stop or just leave. And she told him to come back, just come back. And then they were trying to convince him to go outside and wait, and then they would hand him the stuff through the door. He just kept being like irate and yelling at my mom, F this, and no, I'm getting my things now, and like being really combative and just aggressive. And my sister's trying to calm him down, and my mom's telling him just go, and she's like, you don't go, I'm gonna call the cops.
And the mother said, let's hear that.
Sustained.
All right, so without saying what anyone else said other than yourself and Mr. Jackson, what happens next?
That's when they were going back and forth. I don't know, I'm not saying somebody said it. Oh, well, I guess when they were going back and forth, that's when he was like, I don't care about the police, or I don't care about the police. And mom was like, well, I don't know how to mess up.
Okay, so your mom said something to him.
Yeah, she was like, you can't break into someone's home.
No objection of being hearsay. Not as a restriction.
I didn't know, I couldn't blame her. She didn't blame her. Okay.
So let's just say this. So your mom said something to Mr. Jackson. What was his response, or what did he do, if anything, after that?
He kept saying he didn't care about the police, and then he was like, I got a gun too, I don't care. And then that's how, and then my sister was, well, I can't say what she said, so. Anyway, eventually he got outside, and the police pulled up. I don't know who called them, I don't know how they came, but they were right there.
Okay, so let me stop you for a second. So did you hear him say, I got a gun?
Yeah, that was his rebuttal to my mom telling him he can't.
Objection against her father.
Okay, sustained.
All right, so you heard him say that. Did you see a gun?
Yeah, it was on his hip.
So you saw a gun on his head?
Mhm.
Okay, when did you see that gun?
When they were pushing him towards the door to get him out of the house.
Who was pushing him? You can say that without saying. what-
My mom and my sister.
Okay, all right, so you saw the gun?
Mhm.
Okay, did he ever do anything with the gun?
No, he didn't.
Okay, so you said the police showed up. What happened after the police showed up?
The police came, and at that time, he was like getting his stuff in his car. And the police ran for what was going on, and then they had words and confrontation. My mom spoke with the police, and then they arrested him. The police came to me, and we had a conversation. We spoke to my things with him. No, okay, well.
Okay.
And he went away.
Okay, all right, thank you. Now, I know that you have already stated this in a different way, but I do need to just ask you very specifically, at any time that night before, did you give him permission at all to come into your home?
No.
Oh, all right, thank you.
Cross-examine.
Okay, so
I just want to
How you doing?
okay. I just got a few questions. I actually represent Mr. Jackson. Now, you said you have been knowing him for 10 years, is that correct?
That's correct.
And you indicated you have a child with him, is that correct? Okay. Now, you said that Mr. Jackson called you and said he wanted his stuff. Okay.
Yeah, yes, and no.
Okay, and now you didn't, but your mom didn't know that Mr. Jackson had stuff at your house, did she?
That's correct.
She can't testify as to what someone was knows.
Okay. So to your knowledge, now move on, Judge. Okay, so, but you said Mr. He came in to get his stuff. That was your understanding from what he told you, Mr. Jackson, correct?
Yes.
Okay, and did the things that he took out the house, were they just his belongings? Okay, he didn't try to take nothing else?
No.
Okay. Now you said you fell off the bed, because your bed is high.
I said he pushed me.
Okay, he pushed you. So, but you said your bed is high, is that correct?
It is high.
Okay, anyone, you say, I believe was testified, has it helped or climb up on that bed?
Yes.
Okay, so when he came into the window, how close was he to your bed? You know,
They're close, probably, they're close, the difference between you and this young lady and him.
okay, so when he came into the window, how far away was he from you?
I don't know, like feet, maybe 3 feet
So
away
you can
from
pick
me.
something in the courtroom to indicate where you are as opposed to where he was coming through the window.
He came through the window, he had 4 rooms to be on the floor. Me,
Can you point to something in the courtroom that would indicate how far away he was from
I guess that clear screen in front of you and you.
that far?
No, this one, that plastic right there in front of you. So that far away, that's how far away we were. So I stood up on the bed and that's when he pushed me.
That's about 3.
Oh, 3 feet?
Okay, so was his stuff, as you call it, anywhere near you at that point?
His stuff was like, under my bed.
Oh, okay, so he had to come near your bed, you would agree?
Yes.
To get his thing?
Yeah, but he,
Uh-huh.
but when he pushed me, the stuff
I
was
didn't ask you that.
right there in the feet.
Oh, the stuff was right there in his feet, he pushed you?
They weren't
Okay.
in between he and I.
Okay.
And he didn't have to push me to get his things.
Okay, but his property was under your bed?
Mhm.
That's yes?
Yes.
Okay. And how many bags did he have, if you can recall?
About 3.
Okay, but little bags, big bags, so
Like the checker laundry bags.
oh, okay, okay. And how long have these items been at your home?
Give or take, probably over a month.
Okay, now you said you asked him to come back in the morning, correct?
I mean, yes.
Okay, and you in fact said, I stated today, you did not call the police, correct?
I did not.
Okay, and the fact is, if he had came in the morning, you would have just
Yes.
gave him, flat, gave him his things.
Yeah.
Okay, now, and as to the gun, you said was on his hip, correct? Was it in a holster?
Yes.
Okay, and do you know if Mr. Jackson has a CPL, or license to carry?
I've never seen it, but he told me he did.
Right, he told you, and he's told you that several times, is that correct?
Yeah.
Right. So you're stating that he never lived at that home?
No, he has never received mail with our addresses on it. No, ma'am.
Okay. So how did Mr. Jackson go out the house? Did he climb back through the window, or did he go out the door?
We opened the door and asked them to leave. They were like pushing him.
Okay, did he left?
Yeah. Yeah. With them pushing him, not voluntarily.
Okay, but and he left with his belongings, is that correct?
Yes.
And once he had his belongings, he didn't try to come back in the house, did he?
No.
Right. And the gun that was on his hip, he never threatened you with that gun, did he?
No.
And he didn't threaten nobody in the house with the gun, did he?
No.
Okay. And you indicated your sister and your mother were outside talking to him, is that correct?
They were trying to get him out of the house.
Okay, but
And he was
once,
being belligerent.
okay, but once he got out the house,
He was still yelling outside our house, making a scene.
okay, and so they went out there to talk to him.
No, we were in the house. We couldn't get him out the house.
Okay, so I'm saying after he got out of the house.
He was still yelling, waiting on his things. I'm waiting on another bag and calling us out of our names and
Okay.
being irate.
I understand. So did he have any other bags in the home?
No, I think we had given him everything at the time. So he was gathering them and yelling across our grass, like.
Okay. Just a moment. So what color was the weapon, if you can recall?
It was black.
Okay, and what color was the holster?
I believe it was black.
Do you know what type of weapon it was?
No.
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 No further questions, thank you.
Can you hear? Ma'am, what specifically did he have at your house? You know, what was in those bags?
It was clothes and then a bag of boxes of shoes.
Okay. And you said that window was broken, the lock was broken?
Yeah, you know, the two locks at the top on the twisted thing.
Okay. You saw him coming through the window?
Yeah.
And your bed was relatively close to the window?
Mm-hmm.
Is that yes?
Yeah.
Okay. So he got inside of the bedroom. You said you were sitting on the bed.
That's what made me sit up on the bed on my knees, and I'm like, what are you doing? And he was coming in my window, like he was really in the he hopped me.
You said he pushed you?
He pushed me off my bed.
All right. It wasn't that he bumped into you or anything?
No.
It appeared to be intentional.
It was very intentional.
All right. Did he say anything when he pushed you?
Yes, I moved out my way. He called me out my name. Good.
Did you get in his way?
No, his stuff's on the side of the bed. So, you know, if this is the window, the stuff is on the side of the bed. So he didn't have to touch me in front of him or the bed in front of him to get his things off the side.
You weren't trying to stop him coming through the window?
No, I couldn't. It was so fast, I couldn't even get there. I couldn't believe he was doing it.
Any questions based on my question?
I do have one question. So, ma'am.
Yes.
Okay, was his belongings under your bed or on the side of your bed?
They were under the bed. But in order for him to get to them, he had to go on the side of it.
Okay, and so you were sitting on one side, so he was on the other side?
He couldn't reach it from the other side. Again, my bed is kind of big. So he would have to go on the side to get his things off the side underneath the bed.
So he was gonna have to pass you, go past you?
No, he didn't have to do anything with me.
Okay, but when he got in the window, his things was not, they were under.
They were not at his feet. He could not get them from underneath right there. He had to go along the side of my bed to get them from under.
And was that around you or?
I guess, yes, around me.
Okay.
All right, thank you, ma'am. You may sit down.
Thank you.
Any other witnesses on behalf of the people?
I have no further witnesses, Your Honor.
Any witnesses on behalf of the defendant?
No witness, Your Honor, thank you.
Your Honor, this time I would move to bind over and reserve argument.
Your Honor, on behalf of my client, we feel that, it's always our position, we have not met the burden. My client went to the home as testified by the complaint here to pick up his item. You know, and she has testified that he would have to go around her to get his belongings. He wasn't one there to cause him crying or anything like that. He went to pick up his belongings and he did have stuff
And
there.
then you climb through people's windows to do so? You don't climb through people's windows, do
The people
you?
do
After
many,
midnight?
people do many different things, Judge.
He climbs through a window and pushes her out the way and says, "Get out of my way," saying the B word.
Well, so, Judge, other than that,
Other than that, that's the big thing, and that's the linchpin. That's the assault that they put hanging their hat on.
thank you, Judge.
Okay. Anything else?
No, nothing else.
All right. Court after hearing the testimony of Latanya Waters is satisfied that people met their burden of probable cause as it relates to the charge contained in complaint one. Ms. Waters indicates that the defendant called her, indicated that he wanted to pick up his things that he left at the house. She said, "It's late, come back, I'll give it to you in the morning." That didn't satisfy the defendant allegedly. The defendant came to her house, climbed through a window that was broken, and when she rose up on the bed, pushed her, told her to get out of his way. A nice, not so nice word behind it. And then retrieved his belongings, told the other people in the house he didn't care if they called the police, he has a gun too. He was in possession of a gun at the time that he committed this assault in the home invasion, particularly the home invasion. Court finding these charges were committed in the city of Detroit. The court finding probable cause to believe this defendant committed them. Will bind the defendant over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be June 26, 2023 at 9:00 a.m. Bond will be continued.
Thank you, Honor. Have a great day, everybody.
Thank you, you as well. Good to see you again.
As always, I miss you.
Miss you more. All right. Good to see you.
Take care.
I saw Ms. Fulmar walking around out there.
Oh, okay.
There she is. Come on in, Ms. Fulmar. There's my female defendant there. We ready on Alicia Davis?
Yes, my client is present.
Ms. Tulak show up?
1 second, Judge. Just want to have a few minutes with the prosecutor.
Sorry.
Just like to have a few minutes with the prosecutor.
Who, Ms. Tulak?
Ms. Tulak, correct.
Oh. What's been going on, Ms. Fulmar?
How you doing, Judge?
I'm doing good. How about yourself?
Yeah, I'm doing good, Judge. How about yourself?
Hanging in there.
Good, good. I've been, doing some political work.
Oh, yeah. So
Yeah.
I've been waiting to, follow up on that.
It should be something August 19th.
Okay.
That I'll be letting you know about. All right. Harper came and spoke to the AKA about it at the meeting Saturday, but it wasn't during the meeting, it was before.
Oh,
So, doing now.
interesting.
Yes.
Trying to stay out of trouble.
Are you? Nothing. What you talking about? I know it's a
And stop people trying to.
trouble trying to find you. I
Exactly.
understand. Yeah. I understand. See, when you covered by God's
Right.
protection,
But you always have to be mindful of rules, the same rules do not necessarily apply to you.
yes, yes. That's right. Yeah. Wilding off the wilds of the enemy, fending off the wilds of the enemy.
Lord does a pretty good job of revealing my enemies.
Mm. My brother, yes, and he said, so, yeah. I thought you were other people. As all in God's grace. No weapon formed against you shall prosper.
Amen.
Didn't say it wouldn't form, it said it wouldn't prosper.
That's right. Oh, Mr. Green, where are you?
We're doing a lot of family things. I like it.
That's
Yeah, I've been doing one of them, but I've been doing a lot of family.
Oh, I thought you meant being with family. You mean
Oh, no,
family.
no,
Little.
of course, yeah. No, but no, I actually like that.
Let me tell you, I was in private practice. The only time I was in family law cases, I was dead broke. Stand family law.
After, no, cases I have, they pay me what they're supposed to pay me for what I need to do. I don't have those problems
I didn't
anymore.
have a problem getting paid, I just didn't like the work.
But you have to, I don't take every case. I can not take a case. I've learned. I can't help everybody.
So I didn't know you were doing family law. Okay.
Yeah, I do a lot of divorces, child custody, parenting time stuff. I don't do child support, but I do a fair amount of it. It's still on balance.
Yeah, those were times that I couldn't stand. Nobody was ever reasonable. It was always about sticking it to the other person.
Yeah, I seem to have a little balance. My clients, I have a better quality client.
Okay.
I really do. And I've learned, like, you know, they wanna pick a good way. I wanna pick a good client. How about that? Right? And I don't, just like you were saying, you're kind of a discerner of persons. I've learned to be a discerner of persons. I hear it in 3 minutes. And it, you know, so sorry, yeah. Mhm, right. And it's been good, thank God. So why don't you?
Absolutely. Help yourself. Can you constantly assume constantly? There must be a black hole out in the hallway. I don't see anybody. It's getting lost out there. I don't even have office. I didn't see you over there. You was hiding. You see this big body over there, Judge? I got this big screen in front of me. I can't see anything. All right, here we go. Yes, sir. All right. So there's 2 lots, a 0 to a whole.
Probably not, your honor. Just give me 1 second to talk to my client.
Okay. While you're doing that, I will build this hallmark.
Thank you.
Alicia Davis. Is Davis a whole?
I just have the complaints are not present. Oh, okay, sorry, okay.
Okay, so that looks like it is. So I'm gonna do the, what looks like it's gonna be a wave. I'm gonna see that first. How do you pronounce your first name? So is it Chioki?
Yes, sir.
Okay. Calling case 2357085, people in the state of Michigan versus Chioki Punches. Defendant is charged in count 1 assault with intent to grave bodily harm less than murder or by strangulation. Count 2 assault with a dangerous weapon. Count 3 domestic violence. Here's to the record.
Good morning, Your Honor, Shelley Jean for the people, P number 60249.
Good morning, your honor. Captain T. Ross, on behalf of Mr. Funches, P6313.
Could you just stand at the podium, please?
I'm sorry.
That's okay.
Good morning, your honor. Captain T. Ross, appearing on behalf of Mr. Funches, P6313.
Mr. Funches, tell us your name for the record.
Chioki Apollo Funches.
There's a date time set for preliminary examination. It's 2 lots.
Your honor, at this time, the prosecutor is ready to proceed and my client will be waiting for preliminary examination.
All right, Mr. Funches, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one. You'll be bound over to Wayne County for the circuit court as you stand charged. You understand that, sir? You understand the nature and the purpose of the preliminary examination? Yes, sir. You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit that was probably caused to be committed. Is anyone forcing you to waive your right? Has anyone promised you anything? Are you waiving your right freely and voluntarily? Any objection from the people?
No objection, Your Honor.
The court finds defendant's waiver is made knowingly and voluntarily freely given. The court finds the defendant over to Wayne County Third Circuit Court of Criminal Division for proceedings. His arraignment on the information date and time will be June 26, 2023 at 9:00 a.m. And bond we continue.
Your Honor, may I address the other requirements?
I'm sorry?
May I address the other requirements for?
Yes, go ahead and sign the waiver.
Your Honor, I would ask you to consider allowing my client to have some type of outlet right now. He is currently under house arrest. He cannot work, he cannot do anything. I would ask.
Is he employed?
He was employed, he was working for Great Lakes Landscaping, he was also working for security. So I would ask that.
When was the last time he worked?
First of April.
So chances are you don't have those jobs anymore, right?
My boss told me to call me when this all resolved.
And which ones?
Great Lakes.
That's the landscape?
Yes. Also, to donate plasma twice a month, twice a week. Same time.
You donate plasma twice a week?
Yes.
That's a lot of blood.
This plasma.
Just plasma, okay. So you feeling okay, you sound? I don't want you falling out.
I'm nervous, just nervous.
Okay, no, don't be nervous. You're okay. All right, Pete?
I am not objecting to tether being amended, tether order being amended to allow the hours for work.
All right, so sir, I'm gonna adjust your tether accordingly, but you still not to have any contact with. This is Cornell Squires and Power Squires. Let me have the parties approach them.
On my case,
Oh, that's your case?
witnesses expired on my.
Oh, it's your, oh, I'm sorry, I'm on the wrong.
The sidebar.
Yeah, still. Our reviews.
Okay.
I wrote this in one file, I'm sorry. It's 2 lots, 5.
Sorry, Your Honor, I have the file, so we
Oh,
can
they got
decide.
it. Oh, that's fine. Okay,
Waiver has been executed.
thank you. Okay, so you're not to have any contact with Patricia Johns, understood? All right, I will adjust the tether accordingly so that you can work when you want you to work. So there's 2 lots if you prepare an order to that. Okay.
I will.
Thank you, sir. Okay, Ms. Omar.
Oh, I know.
Just
No. Thank you.
Almost coming back, right?
I think I have it.
Okay, I'm sure you do.
What about if I, that's fine.
That's perfect. Absolutely perfect. Thank you.
Thank you. Everyone have a wonderful day.
Thank you, you too.
Thank you. My name's been okay.
Mr. Drain, can you give me one last favor, can you explain to the complainants exactly why that happened? Calling case 2356923, people of the state of Michigan versus Alicia Renee Davis. Defendant is charged with count 1 assault with a dangerous weapon, count 2 assault with a dangerous weapon. Appearances for the record, please.
Good morning, Your Honor. Shelley Green for the people, P number 60249.
Good morning, Your Honor. Allison Palmer, P 60236, appearing on behalf of Alicia Davis. We're ready, we're not ready to proceed. There are several issues with this matter.
All right, so the court has brought to everyone's attention that the complainant, oh, I'm sorry. I didn't know you said that. We were just practicing. Sorry.
Yeah. Just have a look.
All right, calling case 2356923, people of the state of Michigan versus Alicia Renee Davis. Defendant is charged with count 1 assault with a dangerous weapon, count 2 assault with a dangerous weapon. Appearances for the record, please.
Good morning, Your Honor. Shelley Green for the people, P number 60249.
Good morning, Your Honor. May I please sound court, Allison Palmer, 60236, appearing on behalf of Alicia Renee Davis.
Ms. Davis, tell us your name for the record.
Alicia.
Okay, so this matter was originally scheduled for preliminary examination today. The court brought it to everyone's attention that the complainants in this matter, Cornell Squires and Carlos Squires, are actually church members of mine. And I don't think that it's in the best interest for this court to preside over this case. Appearance of impropriety, the court is going to adjourn this matter and have it sent to another judge, and that judge should preside over this case. Because I know the evidence.
Very well, Your Honor.
Even though I believe that I could be fair if I was the defendant and complaining to the judge, I would think I would feel very comfortable moving forward.
Absolutely. Not to mention, Judge, I just want to bring this up today. We still don't have all of our discovery. I'll let Ms. Green.
So the discovery was an issue at the last hearing. I did send the digital discovery that I had to defense counsel. She then reviewed it, and based on the specific evidence that I had, she was requesting additional evidence, which is she believed was crucial for her case. As soon as she sent that to me, within 15 minutes, I then forwarded that email to the officer in charge requesting all of the additional items. That was on Wednesday, June 7th. I had not heard anything. Thursday, Friday, defense counsel then asked me again about it. I sent another email to defense counsel again requesting, I'm sorry, requesting the additional digital evidence that was requested. I still didn't hear anything. I sent him a subpoena to appear in court today. I did see him outside. He had another case as well, so I'm not sure if he's outside right now, but he said that he was in the process this morning of uploading additional evidence. However, I just want it to be very clear for him that I can't get it myself. It's the officer in charge who has to provide this information. So that's where we are in terms of this.
All right, it sounds like that's gonna be somebody else's headache. So I'm gonna spin this off to me to I accuse myself of signing that form. And we also have to find out what judge this is going to go. I think your OIC just walked in. What's your name for the record, sir?
Detective Brown, Detective Barry Brown.
Yes, sir. I understand there's some outstanding discovery the defense counsel is looking for. What's the status of that?
It should be uploaded to evidence.com. At this time, I uploaded it this morning.
Okay. Okay, fantastic, great. So Ms. Omar, you should have that in plenty of time for this gets set for exam.
That should have been done today. It should have been Friday. Thanks.
Okay.
We didn't. We'll do it. Thank you.
All right. So stand by, we'll find out what judge this is going to.
Very well, thank you.
Can you put the phone in here to see who's going to be?
Yeah, I know I had it somewhere. So what I had to do before is I turned off and fill it out, and then you fill it up to Melody. Okay, and she, that's, you know, who it's gonna be sent to.
Okay.
I can call it and see if they can get it. Like that way. Let me do that.
She said, look, Okay, as this case makes it through its proper channels, I'm not sure how long it's gonna take. But, that's the Chief Judge McConaughey. It's in session. I appreciate your patience.
Sure, no problem.
You have Ms. Robinson here yet?
One second, Jeff.
She is not. Okay. Okay, so, no Ms. Robinson yet?
According to our client, she's in a trial across the street.
Trial.
That's what the defendant said.
Morning, Your Honor. Oh, I'm sorry. Apologies.
Did you tell them? The doctor's right on time. I appreciate that, sir.
Yes, Your Honor, always on time.
We are ready on the main case, it's just going to be a dismissal.
Like the shirt and tie today, Judge.
Thank you, sir. Appreciate it.
Start taking notes from you.
Chief of Staff, not correct. Calling case 2357083, people of the state of Michigan versus Eric Bernard Burnett. Defendant is charged with count one domestic violence, third offense levels. Appearances for the record, please.
Good morning, Your Honor, Shelley Turner for the people, P number 60249.
And respectfully, Judge, Jahakadat PA 2492, appearing on behalf of Mr. Vernon, the state before the court, your name for the record, nice and loud.
Eric Barney, senior.
All right, there's a daytime set for preliminary examination. If you're ready to proceed.
Your Honor, I am not able to proceed at this time. The complaining witness is a Ms. Chantray Vernon. She is the wife of the defendant, Mr. Eric Vernon. She was notified of today's date and time. I just spoke with her on the phone to get the final decision about this case, and she indicated that she would not be coming to court and did not want to go forward with some charges.
And Your Honor, for the record, just so that I'm clear, officer of the court, she did attempt to contact me. I did not know who she was until she identified herself. I ceased the communication immediately. And given the fact that I motioned for a dismissal, Your Honor.
So ordered, the court will dismiss this matter without prejudice. Mr. Burnett, this is, well, was charged as a third offense. Sir, I don't want to see you back here. Again, walk away. You hear me?
Yes, sir. Well, I tried,
Don't tell me anything about the case. I'm just telling you, walk away.
yes, sir.
Stop getting arrested. Coming down here to this kind of foolishness. All right, thank you.
Your Honor, may I approach with the dismissal?
Yes, sir.
Yeah. Mr. Vernon, should they? (1976) would make me feel old. Madam Clerk, would you be so kind to give me a register of actions? Would you be able to do that? $5? Okay, I'll bet $5. I was gonna say, making them go without lunch? Judge, do you have a second sidebar?
Sure.
May I approach?
Yes.
Thank you. That's legal charge. Yes, that. I'll take that. That sheets. Your offense, it's just your reason. Other judges get this up. Okay, I really appreciate your time to be very gallant. Thank you.
Oh, Ms. Robinson. Say Bird.
7 minutes late. I was 7 minutes late. Yes, I was. I can get it to you. Let me know.
Right on time is late. Early is on time.
0. I was at the purpose judge, my apologies. 7083.
Okay, calling case 2357054, people of the state of Michigan versus Clyde Neon Gales. Defendant is charged in count one assault, intent to rape, bodily harm, thus murder or by strangulation. count 2 domestic violence. Defendant has an additional from the third offense notice. Appearances for the record.
Good morning, Your Honor. Shelley Drake, for the people, P number 60249.
Good morning, if it may please the court, Sarah Robinson, P63181 for Mr. Clyde Gales, who's present in the courtroom. Sir, please state your name.
Clyde Gales. There's a date and time set for your examination. Are we ready to proceed?
Judge, I would ask for a dismissal at this time. This case was adjourned for digital discovery, which I have not received. I did receive a download on yesterday, which does not include the discovery from the body worn camera from the 2 officers who interacted with my client, namely Officer Ryan Sharp and Officer Jacob Walsh. In the police report, now Judge, this incident occurred very recently, May 24th of this year. And in that police report, it indicates that they have body worn camera that's functional. My client indicates that this is critical for his defense and even for the preliminary examination here.
Hold on a second. So let's talk about it being critical, because based on the information I see, complaining witnesses are crystal right. Are you saying the police were there during the alleged assault?
There were 4 officers. There were 2 responding to Ms. Wright's home.
Okay, let me try it again. Are you alleging that the officers were there during the alleged assault?
They were there contemporaneously outside, interacting with my client. They were not there. No, they were not there. They were not present.
So
that's correct.
So how is the body worn camera pertinent to the charge of assault, potentially great bodily harm, listed murder by strangulation, as it relates to Crystal Wright?
It will show that Crystal Wright was actually the person who committed the assault upon my client. Based
How
on
is the body worn camera supposedly going to show that?
yes,
That she committed the assault. Okay, so I'm confused.
committed an assault.
And assault after the fact.
I can't say if it was after the fact, Judge.
Well, the police were called there for a reason, right?
The police were called for a reason
So
that Ms. Wright indicated.
I can only assume they were called because of the alleged assault that your client allegedly took.
But my client was, the assisting officers were there at the same time, Judge. So it was in the same time frame they interacted with my client, and he had injuries. So my client would like this court to review his injuries before making a decision on bind over.
Sure.
And Your Honor, that is true. I've spoken with the complainant. She's present again today. And she informed me that in sending him off, yes, he would show that he does have injuries as well. And what she would say is after the attack occurred. So that's the
Which
issue.
kind of makes sense to me, because isn't that why the police were called in the first place? Because of the alleged attack. And then when the police get there, if the complainant then attacked the defendant, that's sort of irrelevant as to these charges that's before the court right now. Now, could it be the basis of some other charges against the complainant? I don't know. That's up to the police and the prosecutor's office. But I'm here regarding the alleged assault that this defendant committed on Crystal Wright.
Right, Judge, and I would again restate that this video would show that Ms. Wright is the aggressor, not Mr.
After the
Gales.
fact.
No, Judge, the 2 officers, Jacob, these
So they
officers,
weren't there during the initial assault.
but they were there right after. He was profusely bleeding. It was a fresh injury. There was blood gushing out of his face.
Okay. Are those officers here?
No, I don't have those officers. I was just going to go with the testimony of the complainant, who will testify that he did have injuries after the assault from her in defending herself. That's what the test, that's what the.
So that's not a
testimony-
dispute. She readily admits that she assaulted the defendant, but she said she did so in self-defense.
Which we would disagree with, Judge, and we think the video would show the severity of my client's injury.
Okay, I don't think they're denying that your client was injured.
Rather, but here it stands, I do believe that the court adjourned this for us to get this discovery. We don't have it. I do believe we're entitled to it. And I don't know why we don't have it. This case is very recent. And
Do you have an OIC here?
No, he is not here. I'm not sure why he is not here. I asked him for the discovery and he sent the discovery, which I did send. And then I emailed him back. He did send the discovery first, but it was not able to be viewed because of the way that it was uploaded. So I asked him to send it again. He did. I indicated that I am able to view it now. However, do you know if your body or camera for the officers or the rest of the defendant? I know the defense counsel wants us because they will likely show that the defendant had injuries as well. So that, I sent that to him. I did not receive anything else. There's no question that the defendant did have injuries when he was arrested.
And it is noted in their report, Judge, that my client is injured.
Okay, so I don't think there's a dispute that he was in.
But it'll show the severity of it. But yes, Judge, but there's a second part that we're entitled to. And once we leave this court, it's gonna be so hard for me to get that. That's just the way it goes, Judge. It'll say, oh, we don't have it anymore. It doesn't exist. Too much time is gone. I have prepared an order to
Okay,
preserve
so
and
I'll
produce.
sign, discovery is ongoing, I'll sign the order, that's no issue.
Yeah, Coach.
Yes.
And prosecutor during high school. I have.
Okay, that the court has executed the discovery order.
Your Honor,
Yes.
so thank you for signing that order. And my understanding is the court is not going to adjourn or dismiss this matter today. Is that correct?
I don't think it's necessary. Although I understand there's some discovery that you need, prosecution stipulating that your client received these injuries as a result of being attacked by the witness at some point in time.
Yes, Your Honor. Now, with the court's ruling and having this discovery order, my client would now like to waive the exam this time.
Okay. Sir, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged with complaint. You understand that?
Yes, I do. Under duress.
I'm sorry, I didn't hear you.
So yes, I do. Under duress.
Under duress. Who's
Saying I can't.
who's forcing you to do this?
I'm doing it myself.
You said under duress. You
Yeah.
know what duress means? That means someone's forcing you to do it.
Oh, no, I'm not being forced.
Let's try it again.
Yes,
You understand you have,
Yes.
all right, the right to a preliminary examination by waiving the same, you won't have one, you'll be bound over to Wayne County Third Circuit Court as you stand charged with complaint more. You understand that?
Yes.
You understand the nature and the purpose of a preliminary examination?
Yes.
You understand, if you were to have one, the prosecution would have to establish that the crime you charged with was committed in the city of Detroit, if there's probable cause to believe you committed it.
Yes.
Is anyone forcing you to waive your right?
No.
Does anyone promise you anything?
No.
Are you waiving your right freely, voluntarily?
Yes, sir.
Any objection from the people?
No objection, Your Honor.
The court finds defendant's waiver is made knowingly and voluntarily freely given. Court will find the defendant over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be June 26, 2023 at 9:00 a.m. The bond will be continued.
Thank you, Your Honor.
Thank you.
All right, thank you.
And that concludes our docket for
Thank you.
today, everyone.
Thank you.
We'll see you tomorrow, same bat station, same bat time. Oh, you did. You need to sign the waiver. Ms. Robbins,
I'm getting a little
you have to sign the waiver form.
too much stuff on myself today.
Huh?
Too much stuff on myself.
That's okay, we all moved a little fast, get a little excited about it, get out of here before 12 o'clock.
It's not gonna last long, though. It's not gonna last long. I'll get you some of it.